Good morning. Thank you all for coming. It's amazing how many people flew into this. But then when I'm looking at, I was talking to somebody from Michigan, there you are, and she just came in from Michigan, flew in like last minute, 2 o'clock in the morning. I'm like, who does that? And then I'm thinking, well, wait, Michigan. Yeah, I'd rather be here. So, yeah. I'm biased. Live here, work here. You know, there were two guys walking in the woods, got their backpacks on, and all of a sudden they find this bear. Actually, this bear finds them. And the bear starts to do what the bears do. You know, they stand up and they look real scary and all that. And the guy to the left drops down to one knee and starts rummaging through his backpack. And the guy on the right looks down and says, "What are you doing?" He said, "I'm looking for my sneakers. Looking for my sneakers." And the guy says, "You can't outrun that bear." And the other guy says, "I don't need to outrun the bear. I just need to outrun you." If you listen to what we're doing today, if you take value away from today, your guys are going to be able to outrun the bears. And the bears are the folks that aren't here. The bears are the people that are not interested like you are in learning, growing, creating not just compliant, but sustainable, successful businesses. You got Mara, you got Sam Tejada, you got Audrey. You have so many amazing resources that have been there, done that, not just in this industry, but in many other healthcare industries. They are built to win. That's how winners happen. That's how people get to stay in the business, and Jen too. So, I mean, tremendous, tremendous resources. Our job is to make you outrun that bear. Actually, forget the bear. All right, so that's the job. And to that point, I want to introduce a few people that you may not see because they're not out front as much. Autumn Galgano in the back. Autumn, if you could stand up. There you go. And then you got Amanda, Carlos, Erica's out front. This is a huge team issue. The truth is, we're just folks with an idea and folks that saw that you all needed a one-stop solution. That's why Ava's here, to be that resource so you don't have to hunt it up. It's all here. You can use what you want, and everything that you need to get in business and stay in business is right here. That's the point. We're very grateful to be together. We happen to all be friends. Half the people in this room are friends. So it's just been a delightful time. You too, Lise. So just a wonderful time, and it's a lot of fun. Let's talk about legal stuff. Legal stuff. There are people that are not in this room, or who may be, but you know, they're acting like us. FDA, DEA, Board of Pharmacy, Board of Medicine, Board of Nursing. Those three-letter agencies, you can look at them one of two ways. They're foes or they're your partners. They're foes, they're opposed to you, they're out to get you, you need to do battle with them. Or they're your partners. Guess which one I'm going to suggest? They're your partners. Why am I saying that? Because you're not going to win. They're not going away. The FDA is not going away. The Board of Medicine isn't going away. The DEA, the Federal Trade Commission, how many people have heard of FTC? Yeah, that's amazing, that many people. Nobody thinks about the FTC in this space. Federal Trade Commission, those are the guys who prosecute promises that you're making in social media and on your internet. What? Oh yeah, and do they do it? They do it regularly. Vitamin C will fix your prostate cancer. Knock on the door. Vitamin C will cure you from COVID. Knock on the door. Well, anything about COVID is going to get a knock on the door, so you can't say that word. It's one of the bad words now. Don't say COVID. Don't say anything in the way that you shouldn't say it if you don't want the knock on the door. Now, if you want to cross swords and you got a whole cash box of money to fight that fight, great. Go fight that fight. Most of us don't, and most of us just want to play. We just want to be successful, we want to help people, and we don't want to get shut down. So how do we do it? We got to know where the bodies are buried. We got to know where we got to sidestep. We got to know our partners, who they really are. FDA, DEA, Board of Medicine, Board of Pharmacy, Board of Nursing, FTC, these are your partners. And what do you got to do for partners? You got to know what they want. You got to make them happy. That's what you got to do. I'm going to help you do that. Okay? Yeah. So here's what you're not going to hear, and here's what I suggest that you avoid. When somebody talks about how you can successfully do battle with one of these government regulators, don't do it. There's such a thing as being right, but there's such a thing of being right and still losing. We've had many clients be right legally and still have to deal with millions of dollars worth of legal fees, fines, Department of Justice, OIG. They have to pay a lot of money. I'm going to give you an example. Pharmacy, compound pharmacy. A guy owns a compound pharmacy. The guy happens to be a doctor. And the doctor goes to his neighbor, who's a lawyer, and says, hey, can you prepare a marketing agreement for me? And the neighbor, who's a buddy, says, sure thing, I'll do it for you like $1,200. Here's a marketing agreement. Here's the problem. The lawyer, does he know about the Patient Brokering Act? No, he doesn't. Does he know about the anti-kickback statute? No, he doesn't. Stark doesn't know. Doesn't know civil monetary penalties. Doesn't know anything about criminal stuff. How many people in this room have heard anti-kickback statute, Stark, safe harbors, things like that? That's right, because you guys, unlike a lot of other spaces, med spa spaces in particular, you guys are healthcare professionals. You've heard these kinds of talks before, so you've got that kind of download and that awareness. That's going to give you a leg up. What I want to do is to help you maximize that awareness that you already have and really create some terrific sustainability and pivot just 5 degrees. Just 5 degrees. Today, let's talk about a little trend. We're at stage 1 of this industry. What is that? Emergence. Emergence. Every corner has an IV hydration. You can go in the book and you can find somebody to come to your house or your office and hook you up in 5 minutes. It's easy. It's easy. Emergence. What's stage 2? Anybody want to guess? Stage 2? Regulation. Why am I saying that? Texas? Anybody hear about an anesthesiologist who just died by getting a Myers cocktail self-administered at home? Who's heard of that? Right. How many people have heard about people getting self-administering Myers cocktails or IV bags at home and then having a terrible health outcome in other states? How many people know Alabama Board of Medicine wants to regulate this industry? They've told us. How many people know that? How many people know that in England, this industry is terrifically regulated? Has to be owned by a physician. There has to be a script. There has to be, here's what's going to happen. Here's what's going to happen. Right now, we're in a place where there's just about no regulation. All there is scope of practice and physician supervision requirements. And they're different for each state. So if you know Florida, that's all you know. And by the way, you only know that for 12 months. Why is that? Because the law changes at least every 12 months in Florida. It changes every time the legislative session meets in every state. Texas, every 2 years, new ball wax. So you have to know all that stuff, and then you have to stay on top of it, and then you have to kind of reassess and pivot. But right now the model is what? What's the model? It's the juice bar model, right? I walk in and I see you've got 40 different things that I can choose from, and I pick the one with the coolest name. Stays up all night. I'm getting that. I just want to stay up all night. Somebody get that. That's the model. Here's the problem. Does that make the FDA, DEA, Board of Medicine, Federal Trade Commission, Board of Nursing, does that make them happy? No, it doesn't. No, it doesn't. Because they're used to a particular way things are done. And the way things are done in healthcare follows a particular trajectory. Diagnosis, prescription, treatment. Diagnosis, prescription, treatment. Documented medical necessity. Who has heard those terms? Documented, that's fantastic. Because that 6 months from now, a year from now, 2 years from now, everybody in this room is going to know that and hear that, and it's going to be embedded into your business model. You will shift, those of you who want a sustainable IV hydration business, you'll shift from the juice bar model into the medical model. You'll interact with people like Sam Tejada, who's way ahead on that issue and is baking in the need for diagnosis, prescription, treatment. You all know the model. Most of you are licensed professionals. You're RNs, PAs, APRNs, physicians. You know these things. And right now we're living in a great time when there's the emergence of this industry, but the regulation is right around the corner. It's absolutely going to happen. I'm not saying it should. I'm not saying I like it. I'm saying it's going to happen. How many people know how law is made? Anybody been involved in the legislative process? Oh, wow, that's quite a few for that. There's two things in life you don't want to see being made. One is sausage. The other is law. Because let me tell you how it's made. I'm a legislator. I want to get elected or stay elected. What do? I look for stuff. It's like, oh, Sally is in my district. She took an IV bag home. She died from a Myers cocktail, or allegedly did, or I can use that story to get elected, stay elected. What do? I run to my state capitol. I tell the staff to draw up a bill. I then sponsor the bill. I get support for the story. The story is Myers cocktail, and these damn juice bar IV hydration people are killing people around the country. It's prolific. There's just dead people everywhere. That's the story. And then I sell it, and I get my buddies who are on the Senate floor or the House floor to vote for it, and then we get regulation. Honestly, that's how it works. That's how it is. And when I saw that, working for the Florida Medical Association 25 years ago, 30 years ago, it was appalling. But you have to know this stuff, right? There's a story. I'm a story guy, and I like stories. I like them. There's two monks. And the young monk is complaining because he's walking around barefoot all day. He's walking around, he's stepping on these pebbles, it bothers him, he's just complaining. And the old monk, because he's a monk, patiently listens for a long time. You know, this is a young monk from the New York area, let's say. Anyway, so the old monk waits for the young guy to finish and then says, well, you can wrap the world in burlap. Wrap the entire world in burlap. Or you can wrap your feet in burlap. The information that's in this presentation and that you're going to hear it's interesting, you're going to hear it among each other too. When we do these conferences and we do these kinds of meetings, I notice two things. Amazing value from people who advise businesses. And number two, amazing value shared between business owners. There are answers right next to you, as Thor was demonstrating. October 25th, 21 memo, FDA. What does it talk about? It essentially talks about compound pharmacies, the regs that apply to them, and how, if you're doing stuff in your office, maybe you should be complying with those regs, which is interesting, right? Because 503A and 503B are the sections of the law that apply to what? Pharmacies. Do they apply to physician offices? No, they don't. Do they apply to clinics? No, they don't. IV hydration businesses? Not at all. And yet this is what that memo a year or so ago had to say. July 2020, Geyer Institute of Molecular Medicine. They go into a medical practice and find all these deficiencies. Now, here's the interesting thing. You think the FDA, DEA, Board of Medicine, Board of Pharmacy want to raid or send subpoenas to medical practices? They do not. They don't like it. They want to be hands-off. Dr. Elmquist some of the other physicians in the room, they understand. They're held to a very high standard. The government regulators know that, they respect that. They do not want to knock on your door with their little windbreakers on, and they do not want to drop subpoenas on these people. They don't want to do it. And yet, what did they do there? They went right in. What did they find? A mess. A mess. So it's happening. That happened in 2020. 2021, we see a memo. So what are we hearing? We're hearing the footsteps of regulation. This is the early signs. (2021) FDA memo talks about compounding regs that apply maybe in physician offices, even though Florida law talks about an exception to in-office compounding for physicians. What do we have here? We've got a lot of confusion. That's why you don't see the horses running down the street with these regulatory bodies, because they usually treat physician offices with deference, and they're not really sure what they're doing yet. Oops. The FTC case. This is a famous case lately because it's been in the news quite a bit. When you look at this in your materials, you're going to be left with one clear thing. If you make promises in your marketing materials about the stuff that you're administering to patients, it's a bad day. You're going to hear from the Federal Trade Commission. You're going to hear from the Attorney General's Office, Department of Consumer Affairs. You're going to hear when you make those claims. So what can you do about it? Well, you can do patient testimonials. You can have a clinical science page on your website that merely says, here's some research from a respected medical journal or professional journal that validates the use of high-dose vitamin C for these things, or vitamin bags for these things, or glutathione, or NAD, or BPC 157, or any thimulant, whatever it is, glutathione. These are things that you're going to see and that you need to be able to be smart about and pivot with without saying, if you buy my stuff, then we're going to cure you of fill in the blank. There's so many ways to do it, and you'll see good ways and bad ways. In your area, you'll see people that are just out there with come see us and we'll fix you. Problem. You know? One of the things that was so compelling to me about Sam's talk is this. He's got a way to validate and personalize an IV bag. Are you kidding me? That sounds a lot like diagnosis, prescription, and treatment, right? It sounds like a medical model. It sounds like you can use a particular process and a piece of equipment to push the model from juice bar model to medical model. That's compelling to me as a compliance guy. That's compelling to healthcare lawyers that are all about building compliant, sustainable businesses. Medical office conundrum. In Florida, they don't apply the pharmacy regs to physician offices, and there's language in the law that suggests that compounding or reconstituting in physician offices is a hands-off affair. It shouldn't be there, should look the other way, shouldn't be an issue. Now that's probably going to sit in that kind of static position until a patient says what? I got hurt in a doctor's office. The moment that happens, there's going to be a lot of, quote, clarification, meaning regulatory activity. When is it going to happen? I don't know, but it's going to happen. So you either, in your industry, define quality with policies, procedures, practices, protocols, or it's going to get defined at you by people whose ambitions are to get in office, stay in office, do the right thing, but not really know what you know, not have the clinical knowledge, not have the industry knowledge. You have to have a seat at that table. But rather than wait for it to happen to you, you can do it yourself. You can do it There are plenty of resources in this room, both the consultants and frankly those in industry, who know how to create a very sustainable, clinically driven IV hydration model. And that's where you're going to need to be to stay in business. See, the problem with this industry is it's easy to get in business. Yeah, cool. Is it possible to close that or, yeah. Thank you. Thank you so much, big help, thank you. Yeah, so it's easy to get into this business because the low cost of entry, the lower clinical skills. We're not doing neurosurgery and facet blocks in IV hydration businesses, right? It's just not easy to stay in business. Anybody who's had a healthcare business for more than 10, 20 years knows getting in business is not the same thing as staying in business. Staying in business implies, in the healthcare space, you're a healthcare business. You know what healthcare policies, procedures, protocols, practices, best practices look like. You know what scientific validation looks like. You know what generally accepted standards are. You know what the standard of care is. What is the standard of care in this industry? Here's the answer, the legal answer. There isn't one. There isn't one. There's no legal standard of care in this industry yet. So what does that mean for you in this audience? Opportunity. You get to create it. You get to create it. What does clinical standard of care mean? You get to create it, you get to codify it, you get to implement it, and then you will see diagnosis, prescription, treatment, documented medical necessity, medical records maintenance. We're going to see all of that. We're going to see it all because you're going to have to do it. This is an opinion from the AMA. How many people know that the American Medical Association has an opinion about this kind of activity? Great, it's good that you do. That's their opinion, it's in your materials, I won't read it. Federation of State Medical Boards. You know, the Board of Medicine in Florida is part of a federation of medical boards that shares information, strategies, including prosecutions and rulemaking. They all work together, they talk to each other. A lot of the regulatory bodies do that. This is what they have to say. In 2020, there was a white painting on compounding medications by physicians. Get it if you don't have it. Because that's what it says. This is what you have to do. They're telling you what they want to see. So that's great, you don't have to make that up. The biggest opportunity is that we got silent partners. We have to make sure that we know what they need, know what they want, and give it to them. At some point, this industry is going to actually go there on a collective basis and say, these are the policies, procedures, practices that we think will keep the public safe, keep you happy, and keep patients getting real value. That's what's going to happen. How do I know that? Because the AMA does it every day. They do that every day. With pharma, with the FDA, with the DEA, that's what they do. They protect you because they're your voice. And those regulatory bodies are sensitive to that. And you guys speaking with one voice is what's most effective, and this industry screams for that. Very early in the emergence of the industry. But for this industry to really be a force of change and goodness for patients, it's going to need a voice. It's going to need to have a voice that isn't a bunch of competitors that get picked off. Because that United We Stand thing, it's true when it comes to regulation. It's true when it comes to law. And that's what needs to happen here. The winners, you're going to know what the laws are. You're not going to find out from a subpoena. You're not going to find out from an investigation. You're going to find out now, early. You know, it's like lawyers, consultants, you know, the truth is that all of your business advisors are a little bit like lines of credit. Like lines of credit. You know, when you go to a bank and you have money available that you don't need, but you might need, that's the best time to get a line of credit, is when you don't need it. The best time to get a lawyer that's in consulting, the best time to get a consultant, to have an Audrey, to have a Jen, to have a Sam, to have these people on your team, the best time to consult with them is when you don't need them. Because when you need them, you're scrambling. And now you're doing things out of desperation, and you're going to miss something that you could have avoided in the first place. So if you haven't done the measure twice, cut once thing, totally understandable, because you are business owners, which means you get absorbed into the daily demands of that business, don't you? How many people feel overwhelmed in their business just about every day? Yeah, right. So there's a difference between working in a business and working on a business. Working in a business and on a business. The stuff that we're talking about right now, that I'm talking about, is really working on your business stuff. If you haven't set aside at least an hour a week to sit, by the way, with your operational chief and ask good questions, then you're reactive. Then you're just chasing problems. Then you're just reacting to problems. I learned long ago, I suck at operations. I'm a business guy. I can't do operations. It's like kryptonite to me. How many people love doing operations in their business? Yeah, like nobody. Right, right. Because business people, entrepreneurs, business people, love this, love the vision, love the mission, love the dedication, love the work. There is no such thing as too much work. You've given yourselves to it. You've given your life to it. You're business people, you're entrepreneurs, nothing will stop you. That kind of person is not an operator. They're not an operator. And how do you know that you're with a business person or an entrepreneur? You have the best time of your life, the best conversations you've ever had, and what happens after the meeting? Not a thing. Not a thing. Nothing happens. You know, people that know us and know me say, I need an Autumn, because Autumn is our chief operator, and she's the reason why it's not me and two lawyers. Why? Because I know I suck at operations, and doing it is just a load, a weight. I was talking with Thor earlier, and he's got other business interests, and he's thrust into the operational space. Any of this ringing a bell, Phil? Phil? Any of this ringing a bell? Working in your business, on your business? Yeah. Yeah, I mean, it's really important, like our highest and best use, you have to know what your highest and best use is. And the stuff that a business needs, you have to import it. Are you a marketer? I'm not. I'm not a marketer. I know how to spell SEO, but I don't really even know what it does. I'm just glad we got it. Autumn told me I should have it, so I'm like, great, go ahead and do that. I don't know what that is. So I'm really good at what I'm really good at, but that's one leg under the stool of my business. It's one leg. It's one leg. I need what? I need marketing. I need sales. I need excellent people who are committed and mission-driven to excellence and who love what they do every day. I need those things. So do you. I need somebody who's operationally driven. They love to figure out how to move the ball from here to there. Every issue that you'll identify, you will, if you're a business owner, entrepreneur, it will just be another thing on your list, another thing on your mind that wakes you up at bad hours. That's what it's going to be. Unless you what? Have somebody who loves operations that you co-create with every day. And then you actually whiteboard, work on the questions at a set time every week, at least every week. How much? Hour, 2 hours, whatever it is. What are we doing well? What are the threats? Anybody heard of the term SWOT analysis? Oh, that's great, SWOT. Strengths, weaknesses, opportunities, threats. Are you doing that? Are you having conversations about what are the strengths? What are the weaknesses? What are the opportunities? What are the threats? And then push the timeline on all of those things. Because the people that get to stay in business, are people who regularly, on a fluid basis, essentially do SWOT analysis all the time, and they're looking at least a couple moves down the road. So when I'm talking with you about regulation that doesn't exist, some of you, probably not you guys, but folks that are not in this room, are like, I don't have to deal with it, I'm not gonna deal with it. That's fine. What it's gonna cause you to do is be on your heels when it happens. It's gonna cause you to have to reconfigure your business, reconfigure who's working for you and what they're doing. Now you can do that, because a lot of people do, including in law and in every business. That's not fun. It's not fun to be in fight or flight mode. Not fun. It's more fun to be looking at the landscape way out in front of you and configuring and adapting your business for sustainability so that you could then focus over time on only what you love doing. Because the dirty little secret is, the more that you focus on doing the stuff you love with the people you love, you have a great day, and you can do that till you're done here on this planet. You can do that every day. What happens to a lot of us is we don't make those changes, so we feel the weight of it, and then we start complaining and looking for an exit. And the truth is, the business could have gone a lot further. The business could have gone a lot longer. So be good to yourself. Focus on what invigorates you, because your business is going to need you invigorated. It's more energy and more time than anybody wants to quantify. You would never want to see how much time and energy you're putting in your business. You just want to give yourself to it. But plan on it, work on the business, you're going to get much better outcomes, and you're going to get to stay in business, and you're going to get a great team of people around you that are dedicated to it as much as you are. Is a prescription required for IV hydration therapy? It depends on what's in it. These are Q&As that are at the back of the presentation. I don't want to drag you through it, but what I'm going to do is flip through this and do what I prefer to do, because it's more fun, right? Is answer questions. The questions that, when we get to this part, one of the things that's fun for me is to see how everybody gives each other the answers too. Because a lot of you know stuff that I've never heard before, you know, in terms of operational, like before Sam came in the room, I had no idea Liquid Vita was doing anything like that. No idea. I'd never heard it. Questions? Let me give one to you. Do you need a healthcare clinic license in Florida? How many people think you might need a healthcare clinic license or an ACA license in Florida to be in the IV hydration business? Yeah, you don't. You don't. You don't. Why? Because HCCLs, healthcare clinic licenses, also known as ACA license, are required if you're providing a healthcare item or service and you're submitting claims for reimbursement. Nobody's submitting claims for reimbursement in the IV hydration business, nor should you. We can talk about that. So if you're providing IV hydration services, it's a cash business entirely. It can be owned by anybody at all in Florida. That's not the case in about 2/3 of the states, by the way. 2/3 of the states have corporate practice of medicine prohibitions that require a clinician to own it, which means that the business people go in a second company called a management company. We can talk about that. How about a need for a medical director? No. There is no need for a medical director in Florida for IV hydration clinic. Why is that? IV hydration, medical directors are required for healthcare clinics, and I just told you, you don't need a healthcare clinic license in Florida. So if you don't need a healthcare clinic license in Florida, you don't need a medical director. Here's the confusion. You know there has to be a certain degree of physician involvement. They're called supervising or collaborating physicians. They're not medical directors. Why are they not medical directors? Because Florida law says, here's what a medical director is, here's how it's defined, And by the way, it attaches to being a healthcare clinic. Well, you're not a healthcare clinic. Not in Florida, not today. So you don't need a medical director. But all the mid-level practitioners that work in your business, RNs, NPs, PAs, they all have requirements attached to their license for a supervising physician. And then they have to file that with their licensing board. Okay? You with me? Questions on anything that I've talked about? Carlos.
Do you need a good faith estimate?
What's that?
Do you need to provide a patient with a good faith estimate?
Tell me about that, because that's cool. We were talking about that the other day.
So, under federal law, anybody that provides self-pay cash business, Meds cost-based IV, has to provide a good faith estimate or offer one to a client before they come to your center to receive any sort of treatment.
That's under
2020, brand new law, just came out.
Yep.
Everybody has to do it.
And now, here's the cool thing about that for your industry. Here's the cool thing about that. Here's the cool thing about that for your industry. You guys are a menu industry. You guys do healthcare on a menu basis. It's not like an orthopedist. I go in and I don't know what my knee replacement's going to cost. I know I got to pay the copay and deductible, and I know I'm going to get bills from people I never met. The anesthesiologist, radiologist, a dude that's in another room looking at something. I'm going to get a bill from those guys, but I have no idea what those bills are. That law that Carlos just mentioned is going to really hit those businesses very hard, because they are required to get a good faith estimate, give it to the patient before treatment. Here's why it'll likely have very little impact in this industry. Because you guys provide services on a menu basis. Here's the stuff, here's the fee. That is compliant and avoids having to go through the machinations that most other healthcare businesses and professionals will have to go through. It's
The good faith estimate has to be an option on your website, first of all. Second of all, if they call your office and they're asking for a quote or some sort, you have to offer a good faith estimate or let them know they have the option to receive an estimate.
Okay, let them know they have the option to receive an estimate once they're in the office.
Before they come. Can you email it to them? And then, or however you're going to send it. Or before they come to the office, they want to receive it there, you present it to them. And it's a little bit complex, but we help basically any type of entity create a good faith estimate to their practice.
Remember, it's an estimate, not the site.
It's an estimate.
It's an estimate.
That's right, it's an estimate.
The website just has to have disclaimer language that as a patient, you're entitled to receive a good faith estimate.
Yep. And we'll be here and can get into more granular detail with you. Yes, sir.
First off, nice to see you again.
You too, man. You too.
So we own a Medicare home health agency. I started this a couple years ago as well for the mobile IV hydration,
Yep.
kind of a holistic approach to my clients. So we're running our regulations and procedures very similar to what we do in that space. Do you think we would be safe in that aspect right now, or do you think we need to dive into like more detail with that?
Angel has a home health agency, and they do infusions in the home health space under their HHA license. And a lot of the stuff that we talked about in terms of the clinicals and following the prescription, diagnosis, treatment kind of model and all of that stuff is baked into an HHA, home health agency. That's how they function. That's how they have to function. They're licensed by the Department of Health. So if you're running it under that model, that's what I would consider to be, from a regulatory perspective, pure gold standard. Meaning it creates so much sustainability that in the event that you are looked at, they're just going to walk off. They're not interested. They're looking for people. They're looking for regulators. When you talk about law enforcement that are the eyes of the regulatory bodies, they're looking for low-hanging fruit. What's low-hanging fruit? No policies, no procedures, no clinical protocols, no medical records. That's what they're looking for. They love that. Why? That's a come and get me. It's an easy day for them. And understand They're there to protect the public, first and foremost, and they get advanced and bonused based on wins, successful prosecutions and fines. That's how they measure successful outcomes. So the deck is stacked against you when they're there. So what do you want to do? You want to be prepared. Policies, procedures, protocols, clinicals, medical record maintenance, all of it. Just like your Dr. Elmquist's practice, just like your doctor's practice. Same thing, HHA, solid. Yes, ma'am.
Yes, can you speak to the states that have corporate practice of medicine
Yep.
policies as it relates to this? I heard you say in Florida, XYZ, but
Right.
Texas.
Texas is a CPOM, yeah. Yeah, so the question has to do with, well, what about those CPOM states? CPOM stands for Corporate Practice of Medicine. What it means is doctors got to own it. Or in the case of IV hydration, clinician has to own it. Because in some states, an RN can own, NP can own, PA can own. And by the way, when we're talking CPOM, here's the singular guidance. There are 50 answers. Meaning, there isn't a federal law that you could look to that answers the question. You have to look at every state law, and they change when? Yeah, pretty much every year. Every year. So getting an answer today for what the law in Texas is, that you were just mentioning, is clear until the next legislative session. Now, Texas meets, their legislature is in session every 2 years, so you get a little bit of a breathing room. But clearly, CPOM state. So what do you do with CPOM states? I'm a business person, I'm not a clinician. I want to be in business in Texas, and I can't own the clinical entity. Here it is. It's called a management model. How many people have heard of MSO, yeah, that's the model. The model, it's a two-company model. One is a clinical entity owned by the clinician. The second thing is a business that's owned by the business people. It's a management company. And then between the two, there's a management services agreement, MSA. And what does the management agreement get? What's the fee? Essentially all of the profit. That's how that works. Now, one size fits all? Of course not. New York says you can't have an MSA where all the profit goes from the clinical entity to the management entity. You can't do it. The fee has to be fair market value. So what do? We engage people whose job it is to determine FMV by doing something called an FMV study. And then they work with the lawyer under attorney-client privilege, double top secret, you know, and they come up with a range between this dollar and that dollar is fair market value. You take it, you file it in your file so that when you're looked at, because a competitor, an ex-employee, it's usually a competitor or an ex-employee complains, and then you get one of these agencies in your office, and you have to be able to show them what? All of it. Not just policies, procedures, all that stuff, but also the FMV study that justifies, substantiates the fee in the contract. And by the way, this is a little nerding out on you, but those contracts, the MSAs, have to be what we call PSA compliant. They have to be personal services arrangement and management contract safe harbor compliant. What does that mean? It means that there are rules at the federal level that delineate the elements of that kind of agreement. We call that PSA compliant. So you need the right management agreement, and the fee has to be right. Lawyers won't tell you what the laws are, what the fees are, or what they should be. By the way, a note, because Gina's there. Am I getting the nudge? The time on that? Okay, cool. Now I want to leave you with something. Here's what you should be getting from the lawyers that you're working with. Straight up. If your lawyer says, I don't know, might not work in the area that you're looking for help with. And this is true not just in healthcare, but in anything. Estate and trust work, real estate stuff, whatever. I just want to give you a look inside the kitchen. If they don't know, or if they jump to know right away, you're usually working with somebody who doesn't know the space. Because the safe space for a lawyer that doesn't really know the place is just say no. Because there's no liability, no risk for him, no risk for you with a no. So if they jump to no real fast, it's not probably their area. okay? What else? Very important to me that you understand this. This is what you should be getting from your initial substantive encounter with any lawyer you work with in anything that needs a law, that needs legal guidance. Ready? The laws, the options, and the risk of each option, so that you make the business decision. The lawyers don't make business decisions. We don't tell you how to do it. We tell you how to do it on options that we tell you what the laws are. We tell you what the options are that are doable, and we will tell you on a risk of 1 to 5 or 1 to 10, this is a level 1 risk, super low. This is a level 2 risk. This is a level 4, it's real high, we're not gonna do that for you because it's gonna create risk. So what do you need to know from lawyers? You need to know the laws, the options, and the risks so that you can make a business decision. That's the job that we have, and that's the job that we like doing with you. Thank you very much. I'll be here all day. Thank you. What's that? I'm sorry? Oh, I do? Okay, I got more time. Sorry.
Yeah. My question was about IV mobile hydration.
Yes, ma'am.
If we have to do IV hydration, what is the requirements for us to do that?
Right. So the question has to do with mobile IV. What's the requirements in Florida? There's 3 kinds of requirements that apply to your business, generally speaking. Ready? Licensure, scope of practice, physician supervision. Those are the kinds of issues that you got to answer. So let's talk about it. Mobile IV. In Florida, we have a licensure issue? We do. A lot of folks in the mobile IV space go, I'm a mobile IV provider of IV hydration. Guess what? I don't need a license. I just go in and do it, and I got 20 people working for me. It's not accurate. You need to be a home health agency. You might also be a nurse registry. But there is a license that applies when it's not just you. There is an area in Florida law that supports the notion that I'm a nurse, I got a car, I got supplies, it's just me going around, that person does not need a license. But a business that has more than that clearly needs a license. We would walk you through which ones are available to you, which ones you like best, because there's 2 that you could choose from in Florida. By the way, how many other states have these kinds of laws? 49 other states. They're totally different in every state. So that's the licensure issue. What about scope of practice? Who can do it? How about an EMT? EMT in Florida? No, sir. No EMTs in Florida can be in the IV hydration space. Why is that? They pick people up from the side of the road, keep them alive. You know, it's a bizarreness, in my opinion. My wife's a retired firefighter and a retired ER nurse. I would rather have her take care of me in horrible ways if I'm in a bad way than a physician who doesn't do that. That's not what they do. And these physicians, they'll tell you, it's not my thing, I don't do that, right? But somebody that fixes it when it's wrong. Paramedic in Florida arguably can, and it's a gray area, so we would talk and make sure, again, laws, options, risks. But so RNs, absolutely. NPs, absolutely. PAs, absolutely. MDs, DOs, absolutely. Scope of practice, venipuncture. Can they do venipuncture? Of course they can. Of course they can. Questions arise in Florida as it relates to paramedics and EMTs. So we now know license, we know scope of practice. What about physician supervision? There's different levels of physician supervision. There's the kind that the doctor's standing in the office. It's called direct supervision. There's the kind where the doctor is telephonically available within reasonable drive time, which, by the way, varies according to what kind of business you're dealing with. That's called indirect or general supervision. Unless you're in the diagnostic space, and diagnostic imaging has 3 levels of supervision. But the bottom line is, what level of physician supervision is required in the IV hydration space? It depends on what's in the bag. Depends on what's in the bag. Generally speaking, if you're doing IV hydration, you're dealing with immunity, you're dealing with inflammatory issues, you're basically pure wellness, and you're not dropping things in, Peptides is kind of is in the vitamin category when you're adding peptides to the bag. BPC 157, NAD, you're adding glutathione, things like that. Those are in the nutraceutical space, and they're looked at as vitamins. So where does the doctor need to be? Telephone. Telephone. But if you're going to start dropping certain things into those bags that require physician presence, then you're going to need to have a physician on site. What are those things? Well, none of our clients nationally do those things. You know, they'll refer out for that, or they'll refer to you, and they'll say, "Come, drop a bag in my client." Yeah. Yes, ma'am.
As far as being concerned in the state of Florida that want to practice medical studies, even if they get their autonomous license,
Yeah.
is there a requirement in the state of Florida that the supervising physician has to be a plastics or derm?
This is a great question. I don't. You probably didn't hear it but I can't hear shit anyway. Anyway, so she was talking about, well, how does this autonomous practice license come into play when you're dealing with an APRN? How many folks are from outside Florida? Okay, for you guys, this doesn't really apply, but in Florida allows APRN, advanced practice nurses, to practice autonomously. They have high level of education requirements, certification requirements. It's a high bar. But if they're autonomous practice certified, they don't need a physician supervisor. They don't need a supervising physician. Generally. Generally, they don't. To your question about when they might, here's where they do. If they're practicing outside primary care or nurse midwifery, they need a supervising physician, because the autonomous practice only relates in Florida to primary care medicine and nurse midwifery, number one. Number two, now that we know that sometimes they need a supervising physician, what kind do they need? The only thing that speaks to the kind that they need is a business where mid-level practitioners, APRNs, are doing facial cosmetic, primarily facial cosmetic. So what is that? It's med spas, right? It's med spas. They're doing Restylane, and they're doing fillers and Juvederm and all kinds of stuff in a med spa environment, and it's an APRN that's doing it. Does that person need a supervising, number one? Yeah, why? Not primary care. It's not nurse midwifery. Unless something bad happens in that chair, all of a sudden, surprise. Anyway, and then what kind of supervising? Florida says that supervising physician, if you're doing primarily facial cosmetic, has to be a board-certified, board-eligible derm, board-certified, board-eligible plastic. No one else. But there's a little exception, because it wouldn't be any fun if it wasn't impossible to understand. The exception is, what if you have it done, the med spa, right where the physician's office is? Well, we know you need a supervising, because it's not primary care, right? And it's not nurse midwifery. What kind of supervising? At the physician's office could be anybody. Could be a pediatrician. Could be a primary care physician. Could be a radiologist. You know, radiologist and a husband and wife, and they're married, and they have a radiology imaging center, and they have a med spa. And guess what? The radiologist can serve as supervising for the APRN that's running the med spa in the same location as the imaging center. Weird, right? Very weird. But that's how that works in Florida. Does that answer your question? Good. Yes, sir. Good. MA or phlebotomist? Yeah, the short answer is, I think your question is, can an MA or phlebotomist start an IV? Yeah. MA or phlebotomist can do an IV, but let me talk about what that means. Phlebotomist can draw blood and start the line if there's proper supervision in the IV hydration business. RN, Yeah. Can they administer it? No. RN. What about an MA? MA is kind of a funny thing. MA means medical assistant. Everybody heard the term MA? Yeah. So in Florida, they're not licensed. They're just, I'm a doctor, and I've been working with Tony for years, and Tony's a great guy, and I totally trust him. And I've trained him to do everything. He's my MA. He's my MA. What can Tony do? Whatever I've trained him to do, when I'm physically there, pretty much. There's lots of exceptions, but pretty much. If I'm in a physician's office and I'm an MA, and I've been trained to drop a line, and I know how to do it, and I'm certified in it and all that stuff, then I can do it. I can do it. Is it because that's what Florida law says? No, it's because that's what Florida doesn't say the opposite of. So it's kind of weird. So most of the laws for licensed healthcare professionals are very meticulous in describing scope of practice. You can do these 25 things. They don't generally say you can't do these other 25 things. With MA, the key is physician supervision. It's direct supervision, meaning doctors there. What about a mid-level being there? No, because the authority that an MA has to do stuff with their hands derives from a physician physically there. MD-DO. MD-DO. Yes, sir. Yes. Yeah. So the question is, mobile IV, now the issue of iron infusion, because I think my iron's low, is that something that we ought to be doing, right? In my opinion, it's something you should not be doing. Yeah, I mean, it's a little bit like the Sam comment. My energy's low and therefore I need B12. You got lay people diagnosing themselves as a recipe for disaster, because when you're looking, I mean, let's take two steps and talk about Matt Gracie's world. Matt Gracie is our dear friend and the medical malpractice insurance expert of the universe in the back. But when he's talking to you about what you're doing, and he says, wait a minute, the patient asked for it, the patient self-diagnosed, and you said yes, and you're a licensed healthcare professional, bad day for Matt, bad day for you. Yeah, yes, sir. Yes, sir.
Piggybacking on that, how about in a doctor's office with a physician present? Would you be able to infuse things such as iron?
Will you be able to infuse what?
Infuse things such as iron.
Yeah.
In the case that a physician
Yeah. So same kind of thing, but you're in a physician's office. Can you infuse iron? In my opinion, this is not from law. This is honestly common sense stuff. This notion that patients can self-diagnose and self-prescribe, you have to get away from that when you're dealing with pretty much everything. But iron, yeah, that's a problem. That's a problem.
On that very same note, earlier you mentioned about being able to do things in the physician's office with a physician on location, a supervising physician's side. From the market perspective, some patients may not feel comfortable sharing a lobby with sick patients.
Yeah.
Is it possible to have like a location that we have like two entrances?
Is it possible for a physician office to have two entrances? You know what? It's a brilliant pivot, because it's very common in the physician world. You know, how many people have heard of concierge medicine? So if you're paying $2,500 a year for the privilege of being treated by somebody who then bills your insurance company, you generally want to feel like you're treated special, different. So it's really common for there to be two separate patient experiences in the same physical space. Is it legal? Yes, it is. It's smart too. Because if I'm going in because I partied and I just want to feel better, I really don't want to be with a mom and her kid and you got all this boogers happening from the kid, right? Don't want it. Especially in this day and age when everybody's super sensitive of like, I might catch something and die. So yeah, so I think it's a really smart move. Yes, ma'am.
From a regulatory standpoint, you brought it up for
Great question. So she's an APRN, and she's asking about standing orders. She's asking about physician supervision. And your first question was about? It'll come to you. Just interrupt. IV therapy isn't under the umbrella of autonomous practice. Okay, great question. Back to it. Autonomous practice APRN, that autonomous designation and the ability to step away from a supervising physician only applies to the autonomous practicing APRN that's practicing primary care and that is practicing nurse midwifery. So the question is, well, what about, where does IV hydration fit? And the short answer is, who knows? That's the truth. It's not addressed. Like, where is primary care medicine for an autonomous? Where's it defined? It's not defined. Can you make the argument that hydration, IV hydration for immune boosting or inflammatory issues or whatever, can you make the argument? That's primary care medicine. Absolutely. Absolutely. Are you 100% certain in being able to make the argument? No, you're not. So this goes back to the laws, the options, and the risks. What I would tell you if you asked me and we're talking about the thing, I'd say, look, there's a law. It talks about autonomous practice. It only applies to primary care and nurse midwifery, and it's completely absent from Florida law where IV hydration fits within primary care. Is it part of it? I think you can make an argument to that effect. And what does making an argument to that effect when you're dealing with a legal issue mean? Anybody? Money. That's what it means. It means you're going to have to pay a guy like me to, quote, make the argument. You get a subpoena, you get a complaint, you get a probable cause, what's something called a 45-day letter. We have to respond to it. We have to make the case. You've spent thousands of dollars with us because you want to make the argument that IV hydration is primary care and therefore I don't need a supervising. What's a better pivot? A smarter, in my opinion, a smarter business pivot, if you can do it. Have a supervising. Have a supervising. They won't charge you anything. They know you, they love you, you know them. They want to do it for you because they want to help you. Get one. Right? That's what we do in areas of uncertainty. We look for inexpensive, a very convenient certainty. How do we create it? We find the solution. It's a much better, and the fact that you've done it is very forward thinking and very smart. And if somebody wants to put money aside and fight the fight and make the argument and hire a lawyer, us, anybody, to fight that fight, they're welcome to do it. And they would probably, in my opinion, today, win. It'll cost a lot of money. Yes, ma'am. Lisa.
So what am I doing? Am I drawing lots on everybody? I don't want to do that.
Right. So the question is, she's a physician, and to the point of needing to document medical necessity, does that mean I got to draw lab work on everybody before I give them IV? The short answer is no, but you got to have something. So are there things out there? I mean, look, the fact that you would even do something like a mini physical to come up with clinical indicators that suggest that that's a good thing to do, or something like a scaled back AWV, or it's part of their annual wellness visit or something like that, and it fits in on a strategic basis based on clinical or physician-patient interaction, and you document that you did that, that's great. That's diagnosis, prescription, treatment. Yes, ma'am. Is there anything that says it's got to be blood work? There isn't. I mean, you treat a ton of people for a ton of issues that you're not pulling urine or blood. You know? You're trying this, you're trying that. You think that the risks of trying this or that are low, so you do it. That happens all the time. You get people that don't have adequate coverage for lab, or you don't think that it's needed for whatever reason. It happens every day. The important thing is your brain's at work and your pen is at work. You documented what you thought and what you did and what you recommended. That's the thing. That's the secret sauce. Yes, ma'am.
Position also, so back to the MA question. I'm not sure exactly what constitutes an MA in Florida. What is the definition? Who's an MA? That can administer the IVs when the physician is in the office, as you said. And follow-up question to that, if the physician is not in the office, can an RN administer the IVs?
Sure, sure. So the question has to do with not sure about the supervising issue on the physician and what's an MA? So that's the first question. The second thing is, can an RN do it, the IV hydration? MA is defined in Florida law, and it's somebody who's certified as an MA or designated as an MA by the supervising physician, and the supervising physician is physically there when the MA is doing clinical things. That's what an MA is in Florida. Can an RN drop a line into a patient? The physician is physically there? Absolutely, every day, all the time. If they're not there, then the nurse needs a protocol, and the doctor needs to have a standing order about what she can do when he's not physically on premises and he's available by phone. I mean, the last thing you want is the patient anaphylaxis, and you don't have a protocol. You don't have a crash cart. You never anticipated it, and now you get a 911 transfer, and you get what? Now you're on the phone with Matt Gracie, because you're going to notify your carrier. Is there specific documentation for an MA? Yes, there is. Florida allows it, but doesn't require it. So my strong suggestion to you is when you're looking to reduce your risk, when you're looking to reduce your regulatory risk and your malpractice risk, get your MA certified. Require them to get certified. And then require training. You know, they have certain CEUs that are required as an RN. Great. But there aren't any CEUs required of an MA. Require them to create your own policies and procedures. Because if you don't create the protocol, it's going to get created at you by people that really are not qualified to. Yes, ma'am.
I just wanted to piggyback on a couple of things. With your iron being mobile, some labs where you want to tailor your treatment to each client.
See, I think that's the kind of information this industry really needs to consider and codify for themselves and for each other.
In this town, and I mean, I don't
Yeah.
have any beside me.
Yeah.
You know, and so clients will call me, and I am just doing mobile. And
Right.
I will provide iron if it's indicated for this.
Right.
But if I don't have the information to work with, I'm not going to do it.
I mean, we've seen all these issues in other wellness sectors. HRT is famous for patients self-diagnosing and then overutilizing because they think testosterone is like, you know, M&Ms, the more, the better. And they don't understand, you know, that low energy and is related to multiple functions. They've got terrible blood sugar management. They've got all kinds of adrenal issues. They're not addressing because they are watching an ad on the internet and deciding in 5 minutes, I just need more of that, and then they're walking around with enormous testosterone levels, and nothing's really being handled from a healthcare perspective.
Function at a 400
Yep, yeah,
optimally, where another man needs 800.
exactly, exactly, exactly. But the point, your point, and I think the point in the room among the clinicians is you guys know you got to pull the clinical decision making and advice back into the hands of the clinicians. And you do that, exactly, and then you create a very sustainable model that anticipates regulatory impact anyway. Yes, ma'am. That's right, MA, physician on site. Yes, ma'am. What about what? LPNs typically require on-site supervision of their professional, whether it's an APRN or an RN, but then the RN, you kind of got to layer it in. The LPN, generally they don't act without any higher level clinical supervision, number one. Number two, it depends on how far up you go on the chain in terms of what the scope of practice is of the LPN. And then when is an LPN really an LPN and when are they an MA, right? Because if you want to exceed the LPN license of an LPN, you can. But you have to do it properly. How do you do it? You MA them. And then this physician supervision issue gets codified because the physician has to physically be there. Why? Because that's what they got to do for MAs. So you're you're playing a little bit of whack-a-mole with the supervision and scope of practice license. But the good thing about it is that in most states, these laws are easy to, they're right there. So when you squeeze one end of the toothpaste tube, the other one will bulge. So you have to balance it out. Yeah, both those issues. Yes, ma'am. PA on site?
Any sort of practitioner that you can use to draw the IVs and do the infusion?
Are there any mid-level practitioners are you talking about?
The PA on site.
With only the PA on site?
Can they work as a supervisor to an MA or to any of these?
Can the PA work as a supervisor to an MA? No. The physician has to be on site for an MA. Yeah. 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 So you'll see, as you know, you'll see surgical PAs and they're opening and closing, and the supervising physician is in the next OR, and they're bouncing back and forth between cases all the time. That happens all the time. But you're talking about direct supervision. Again, it's the highest level of supervision, doctor there. Even with something like doing surgery or opening and closing, they do it all the time. You get direct. Carlos.
What's the importance of having standard procedures documented, keeping all these policies that we're talking about?
Yeah. I think the implication is when you have these kinds of questions and you get the kinds of answers that you're getting in the room here, you got to codify them, and then you got to in-service your staff, because then, there's an efficiency issue, right, in terms of function. Every time you're taking 3 steps and you're wondering whether you should take the 4th, you're slowing yourself down and you're creating problems in your business. But if you have policies, procedures, protocols, and you're training your staff, you've in-serviced them, everybody knows how to roll until the legislature changes it. Yes, sir.
Yeah, now that you mentioned policies and procedures, is there, legally speaking, an entity that provides that information, or?
The question is policy, PMPs. Is there a legal entity that provides those services and those documents? The short answer is yeah. If you look on the internet, you'll see that industry-specific or license-specific organizations will often have suggested PMPs. They often do. And that's a great place to start, in my opinion. But they do those things on a one-size-fits-all. It makes people like Jen nuts. And one-size-fits-all. And the worst thing you can have in your practice is rules and regs, policies and procedures that you're not implementing, you're not following. You're better off without them. You're better off without rules, regs, policies, and procedures than ones that you got, that you implemented, that you're not following, you're violating. Okay? Because, it doesn't make sense to explain why, but it makes our job really, really tough when we have to defend you. But so what should you do? You should look and you should see what's out there as a platform, as a template, and then ask yourself, what would you like? And then modify it. And then have a healthcare lawyer look at it, see what you got, make some suggestions, push it this way and that way. And make sure at the end of the day, whatever you end up with, you're willing to implement it and you do implement it. In law, there's something called a sham arrangement. Here's what it looks like. I heard I need an agreement. I paid somebody to do the agreement. I have everybody sign the agreement. I don't implement the agreement or ensure on a regular basis that people are complying with that agreement. When the regulators come in and look and they see the agreement you're not really ensuring compliance on routinely, they call it a sham arrangement, and it makes them very angry. Even though you probably intend it to be a sham arrangement, they think, well, the reason why you have it papered up is to be sneaky and tricky. That's why you're not following it. Yes, ma'am. Yes. Open it. We like worms. We're all about worms. Yeah, ketamine clinics. Gosh, we are pre-wave on ketamine clinics, right? We're talking about ketamine clinics and compliance. You know, if you drive down the highway in California, you'll see off-ramps and signs for stuff on the off-ramps. Guess what some of the signs are for in California? Ketamine clinics. Ted's Ketamine Clinic. Just drive off, plug in. That's the state of the proliferation in the state of Texas. We haven't seen that yet in Florida. We do have regs in Florida on ketamine clinics. They're regulated. They will be more regulated. And we're seeing, I call this pre-wave, meaning we're seeing a light emergence of ketamine clinics. What we will see is business, private equity, venture capital money enter that space, and there'll be national platforms within the next 12 months. I know that's going to happen. So what are we going to do about it? The same kind of takeaways here that you're getting in this room are the same takeaways that apply to ketamine clinics. If you think that the regulations that exist today in various states, and by the way, they're usually state-specific, are the ones that you're going to be able to ride to retirement and acquisition, it's not true. It's not true. So what you need to do is you need to get medical advisory. You need to get your medical advisors together, your industry advisors, a PharmD, sit down and say, what are the policies? What are the procedures? What are the protocols? How do we in-service everybody to do this right? And then adopt them, implement them. Because again, if you don't define quality, it's going to get defined at you by regulators that really don't know your business and don't know your clinicals. But ketamine clinic, here's where I see, if you're interested in this, because I'm very interested to see where we're going with essentially MAT, medical assisted treatment for depression, suicide, mental health, because we're seeing it not just with ketamine, but MDMA, LSD, low dose psilocybin. These are things that in the PTSD community especially, and in the trauma community are immensely effective, not just anecdotally, but there are scientists that are at the forefront of ketamine research that are saying things like this. 1 IM injection, and I forgot what the dose is, ketamine, suicide ideation's gone in an hour, stay away for a week. Alternative, SSRIs. SSRIs, 6 to 8 weeks to create any kind of clinical outcome, and they have something like 40% effectiveness. 80% effectiveness from the physician on the front line in ketamine research. 1 hour effective before it's effective, 1 week half-life, do it again. And then you're talking about low dose, because low dose is really more of a mental wellness protocol. But it's fascinating, right? And when we're looking in the veteran space and we're looking in first responder space, and these folks are getting all kinds of trauma, both physical and emotional trauma, psychological trauma, the outcomes in that space from those kinds of treatments, psilocybin, ibogaine, MDMA, ketamine, they're all in a class of drugs and in a class of psychiatric treatment that is emerging in prominence in a very, very rapid way. The FDA just issued notice about, I don't know, 3 weeks ago, a month ago, that within the next 2 years, they're going to green light all those treatments because they can't ignore the clinical efficacy of those treatments. You get a lot of people suffering with very human illnesses and challenges, and if we can fix it and manage it and get better outcomes faster, longer, we're going to do it. This country is going to have that probably with all of those platforms and more that I don't even know about. But we're tracking it. We do have clients in that space, so we need to track it. But I'm personally fascinated by anything that works, especially stuff that works that is emerging. By the way, all that stuff, very active in South America, very active in Europe, very active in Central America, just not here, you know. Is it more regulated than IV clinics, IV hydration clinics? Yes, it is. In most states, yes, because ketamine is controlled substance. You know, yes, ma'am. Yeah. Question, telemedicine, physician supervision of an MA. Does telemedicine-based supervision work for an MA? It does not, because telemed is what's called indirect supervision at best. And I say at best because indirect supervision requires a certain ability to get physically there if you need to, right? And obviously somebody in Ohio can't get to Palm Beach. So no. So the short answer is telemedicine is not an adequate substitution for the direct supervision requirement of an MA by an MD or DO. Yes, ma'am.
So they've established that an autonomous nurse practitioner does not need a supervising MD for primary care, but if there's no primary care, how does a mobile IV hydration happen?
I didn't catch the last part, but if,
Mobile IV hydration play a part of that? There's no primary
sure, great. So you adequately captured the fact that autonomous practice APRNs in Florida do not need a supervising physician if they're practicing primary care medicine. How does it dovetail with mobile provision of IV hydration? The short answer is it's a question mark. We don't know. So to the earlier question and conversation, you've really got two choices. After you know what the laws are and the options and the risks of each option are, you're going to be left with two options. Either go without a supervising and be prepared to say, I'm an autonomous practice APRN, I don't need a supervising for primary care. Mobile IV hydration that I'm doing, that's primary care. And then defend yourself in the event you're investigated. That's option one. Or option two, get a supervising that can supervise indirectly, and so that when you do get looked at, you can say, I got a supervising, go away. Yeah, that takes, I don't know. You can do that yourself. You don't need us for that. Yes, ma'am.
For the CPLM suites,
You're the only, by the way, I have to point out for the fashion-aware people in this room, there are two women wearing green. One is Amanda, one is you. That's awesome. That's like, that takes a lot of, I like it. It's good. It's good. Go ahead, sorry.
for the CPLM suites, how lengthy is the MSA? Like you talked about the fair market value study. Is that federal or is it state specific?
You talking about FMV?
Yeah.
Okay, it's a great question. But it's only a great question for a healthcare lawyer that wogs out on this stuff. You guys will glass over after about 5 minutes. She wants to know, FMVs, do we need that for all these things? The state, or is it just federal specific? Right? And the short answer is, I'll condense it. Fair market value in anything involving the exchange of money, including compensation, including lease payments, including equipment rental, including management fees, all of that stuff, payment of money from A to B in the healthcare space is regulated. What's it regulated by? Laws like Florida Patient Self-Referral Act, Patient Brokering Act, Anti-Kickback Statute, Stark Law, add them all. One of the elements of compliance, and there's kind of a common thread, is if you want to get a lease right, one of the elements of requirements is the same as if you want to get a space rental right, if you want to get compensation of a physician right, if you want to get a management fee right in the healthcare space. What is that? Well, there's a number of common threads that make compliance happen for all of those weird circumstances that don't seem connected. One of those threads between all of them is fair market value. So, to your question, does it only apply when you're dealing with Medicare, Medicaid, Champus, TRICARE, state or federal health care program? We know it applies there. Why? Because the anti-kickback statute says it does. What about state law? What about Cigna, United, letters, PIP insurance? What about that? And that's the only payer of that healthcare business. Does that fair market value thread weave its way in terms of compliance with those non-governmental payers? It does in Florida. I'll tell you how. There's a magic law. It's an annoying law, honestly. It's even to me, it's annoying. It's called the Patient Brokering Act. Florida Patient Brokering Act is a law that looks and acts a lot like the anti-kickback statute. and which is a federal law that only applies if you got Medicare, Medicaid, Champus, TRICARE. But the PBA applies with everybody, including cash-paying people. What's the home base on the PBA? That you're compliant with the federal law, even though there's no state or federal health care program. So it's a long-winded way of saying that if you want to be sure that you're PBA compliant, Florida Patient Brokering Act compliant, then you will also weave into your decision making and when you're creating all these documents that involve payment of money from here to there, that it's fair market value. And there's a number of ways to do it. There's the more expensive, more certain way, and there's the less expensive, and sometimes, frankly, just as valid way. In the space rental, well, you're paying $20 a square foot plus $3 of CAM, and that's the space, and that's what your neighbor's paying. So you can kind of get a feel for FMV, but if you ever need something more assurance, and Carr Realty's here today, they're great. And they're going to tell you some things about how they advocate for practice purchasers and practice purchasers and tenants in a very unique way. They'll know to pick up the phone and say, hey, we need this FMV'd. Anytime you have a relationship between two healthcare professionals or two healthcare providers, for example, a hospital and a physician for an MOB rental. That's going to be very strictly regulated, and they will make sure that's FMV because they have their butt on the line in a serious way, right? But it's also context.
Yeah, you don't have a mobile ID business, and then
Yeah.
you want to go, let's say, car or something, you're going to need, and a lot of, this is a lot of clinicians.
Yeah.
Want to be medical directors because they're very hands-off.
Right.
Being where you're providing the mobile and maybe not the license, and some of these obviously states are CON. So is it a very lengthy process?
Is what a lengthy process? Determining fair market value?
Yeah.
Depends on how busy your consultant is. It can be a couple of weeks, it could be a little bit longer. But in that space, when you're talking about a medical director or a medical consultant to a mobile IV, in my opinion, unless that person, if that person is a source of patient referrals, you have to FMV it because the risk is significant from a regulatory perspective. If they're never referring and they're not going to refer and you just need the medical input and oversight, that's a different level of risk. And in my opinion, it pushes you to a less intensive form of FMV process. So it's a little bit, it's the art of what we do as opposed to black and white. It's not black and white. Yes, sir.
Does IV therapy qualify for HSA funds?
Does IV therapy qualify for HSA funds? I don't know. Carlos, what do you think? Amanda, you guys seen anything like that? I've never looked at it. HSA? God, HSA seems to extend to so many things. If you're a medical practice, great point. Great point.
But they've never been audited either by the IRS.
No, but they wouldn't get audited. It'd be the person who's trying to use their HSA funds. God, my accountant will tell me some shocking things. I never knew a massage chair is a business expense because it's health related. I'm like, what? I had no idea. Yes, sir.
What are the pitfalls or concerns with partnering with a private entity, say in a steer setting, that hosts events where alcohol is involved and you as the high-penetration there?
What kind of alcohol? Any kind in particular? Is it tequila? Because I'm going to need notice.
Offer this service in a non-appointed, non-scheduled fashion.
Yeah. You're talking about hosted events that include alcohol, the legal responsibility for the host?
Sure, I mean, just anything from
Yeah.
partnering with that
Yeah.
entity.
You have liability. There's something called dram shop laws, which basically created liability in bars that sent people home that were obviously drunk. And for years, it was like, well, that's on the drinker. And then what happened is there was a series of cases around the country that created liability in the bar because you had somebody literally fall down drunk that they kept serving, and then they went out and injured people. Is there liability if you're hosting an event where there is alcohol? Yes, there is. Yes, there is. Straight up. And what does that tell you to do? Tells you to use some common sense and keep some eyes open. If somebody's got a problem, you need to get them a ride home. And you need to diagnose the problem before there is a problem, ideally. So, and then, you know, from a, I would say from a perception level, beer and wine is one thing and bourbon is something else. But in my opinion, it's a minute difference. Fundamentally, you're hosting an event, you're inviting people, and then you're sending them out. Somebody's obviously drunk, or you don't have people to ensure safety. It's the same thing as if, you know, you're in an active shooter environment and you didn't do anything. You got no law enforcement there, you got nobody with eyes and ears, and you have no response capability. So, yeah, there's liability. Yes, sir?
Piggybacking off of what he just asked then too, is in what ways or consideration should there be related to the informed consent and the ability to be able to knowing that you're in the environment with alcohol and everything else? How does
Yeah,
that play into your kind of
that's a great point. Now you're thinking thoughts that I like. You know, that's cool. So the question is, would you capture in the informed consent from the meeting attendees something related to alcohol usage and that sort of thing? I think that's great. I like that idea. I don't think I've ever seen it, by the way. I think it's great. I've been doing this for 35 years. I don't think I've seen that. But I think that's a great innovation. I'll be around and we'll talk.
Mr. Cohen. Nice
Thank
big
you.
round of
Thank you.
applause.
Thanks, man. Thanks for your help. Appreciate it.